Good morning. Good morning, everyone. Well, we get opinions in 23 minutes, but we actually just got an emergency docket order from the Supreme Court that effectively reinstates a district judge's order to require the Trump administration to pay, yes, today's an opinion day, about $2 billion in foreign aid. So that actually came down just a few minutes ago. Thank you, nobody of note. I think we should check out the decision from the court, but it effectively is denying President Trump's request to not pay this $2 billion in USAID spending. And it was a divided court with the Chief and Justice Amy Coney Barrett joining the court's three liberal justices in the majority, and the dissenters were Alito, Thomas, Kavanaugh, and Gorsuch. Hote, am I indoor because of the weather? No, I'm just indoors this morning. I will be out at the Supreme Court once we get closer to the end of the term, or when I'm there for a big argument and there's an opinion day at the same time. But DC is expecting crazy weather today. We might get tornadoes. So I think that we should look at the decision we just got from the court on this USAID funding. People yesterday on the live were asking about it. This is an emergency docket or shadow docket order. So it comes down in a different way than the merits decisions that we're going to get in 21 minutes, one or more opinions from an argued case this term. Yes, you stay safe in North Carolina too. Only $2 billion. Okay with that. All right. So a lot of folks were watching this case. Again, the Trump administration was trying to cancel about $2 billion in aid, foreign aid and assistance. A federal judge effectively issued what's called a TRO, what the judge called a TRO. I think the dissenters in the Supreme Court quibble with it being a TRO. But it basically had the effect of ordering the Trump administration to pay out this money. And it all got paused. It went up to the Chief Justice. The Chief Justice issued an administrative stay. But today the court lifted the administrative stay, which puts back into effect the judge's order, effectively requiring the Trump administration to pay out this money. So I'm going to read briefly from the majority, and then the dissent is actually longer here. And again, this was a narrowly divided 5-4 decision that just came down. This is not a part of the opinions that we're getting in 20 minutes. This is separate, but we were waiting on this one. So this is the majority. On February 13th, the United States District Court for the District of Columbia entered a temporary restraining order enjoining the government from enforcing directives pausing disbursements of foreign development assistance funds. The present application does not challenge the government's obligation to follow that order. Then on February 25th, the district court ordered the government to issue payments for a portion of the paused disbursements, those owed for work already completed before the issuance of the district court's temporary restraining order by 11:59 p.m. on February 26th. All of this happened on a truncated timeline. Several hours before that deadline, the government filed this application to vacate the district court's February 25th order and requested an administrative stay. The Chief Justice entered an administrative stay shortly before 11:59 and subsequently referred the application to the court. The application is denied. So again, for those who are just joining, we're reading the emergency decision that just came down from the Supreme Court. We're still getting opinions in 19 minutes, but this is the order that reinstates a district judge's requirement that the Trump administration essentially pay out $2 billion in foreign assistance and aid. Thank you, Jay. Given the deadline in the challenged order has now passed, and in light of the ongoing preliminary injunction proceedings, the district court should clarify what obligations the government must fulfill to ensure compliance with the temporary restraining order. With The order heretofore entered by the Chief Justice is vacated. That's it. 1 page from the majority. But then we got a much longer 8-page, 7-page dissent from the 4 dissenting justices who absolutely strongly disagreed here: Alito, Thomas, Gorsuch, and Kavanaugh. They are dissenting from the denial of the application to vacate the order, which is a fancy way of saying they would have kept the pause in place and agreed with the Trump administration that they didn't have to pay out this money right now. Okay, so this is how the dissent begins. Does a single district court judge who likely lacks jurisdiction have the unchecked power to compel the government of the United States to pay out, parentheses, and probably lose forever, in parentheses, $2 billion taxpayer dollars? The answer to that question should be an emphatic no, but a majority of this court apparently thinks otherwise. I am stunned. In capsule form, this is what happened. Respondents are a group of American businesses and nonprofits that receive foreign assistance funds from the State Department and the U.S. Agency for International Development. They brought suit and claimed that the current administration's temporary pause on foreign assistance payments is unlawful. On February 13th, 2025, the district court issued a temporary restraining order, TRO, requiring the government to halt its funding pause, which means pay the money. It based that decision on a finding that respondents are likely to succeed in showing that the government violated the Administrative Procedure Act. After issuing the TRO, the district judge grew frustrated with the pace at which the funds were being dispersed, and on February 25th, he issued a second order requiring the government to pay out approximately $2 billion. The judge brushed aside the government's argument that sovereign immunity barred this enforcement order, and he corrected that, unless corrected, would prevent any higher court from reviewing and possibly stopping the payments. First, he labeled the order as a non-appealable TRO, and second, he demanded that the money be paid within 36 hours. This left the government with little time to try and obtain some review of what it regarded as a lawless order. For those who are just joining, we're reading the court's emergency order that effectively rejects the Trump administration's efforts to cancel $2 billion in foreign aid and assistance. It just came down. We're still waiting on decisions from merits cases that are coming down in 15 minutes. But effectively, this is a loss for the Trump administration, and they will have to pay out about $2 billion in aid. I'm reading the dissenting justice's opinion, dissent from denial, and that is Alito, Gorsuch, Kavanaugh, and Thomas. I'm going to continue. This left the government with little time to try and obtain some review of what it regarded as a lawless order. The government moved for a stay pending appeal in the district court, but the judge shrugged off the government's sovereign immunity argument and ignored the government's representation that most of the money in question, once dispersed, could probably not be recovered. The government quickly filed an appeal in the United States Court of Appeals for the District of Columbia, but with only 4 hours to spare before the payment deadline, the D.C. Circuit dismissed the government's appeal because it took the district court's TRO label at face value and determined it lacked appellate jurisdiction. Typically, you can't appeal a TRO. A TRO is, well, they're going to explain. With nowhere else to turn and the deadline fast approaching, the government asked this court to intervene. At the last moment, and this was quite true, the Chief Justice issued an administrative stay. Unfortunately, a majority has now undone that stay. As a result, the government must apparently pay $2 billion post-haste, not because the law requires it, but simply because a district judge so ordered. As the nation's highest court, we have a duty to ensure that the power entrusted to federal judges by the Constitution is not abused. Today, the court fails to carry out that responsibility. Time does not allow a lengthy discussion of the legal issues presented by this case, but a brief summary suffices to show that the district court's order should be vacated or at the very least stayed. To start, it is clear that the district court's enforcement order should be construed as an appealable preliminary injunction, not a mere TRO. A TRO, as its name suggests, is temporary, and its proper role is to restrain challenged conduct for a short time while the court considers whether more lasting relief is warranted. The order here which commanded the payment of a vast sum that in all likelihood could never fully be recovered, is in no sense temporary. Nor did the order merely restrain the government's challenged action in order to preserve a mandatory injunction requiring affirmative action by the government. And given its likely irreversibility, the district court's enforcement order effectively gave respondents a portion of the ultimate relief that they seek. And for these reasons, the Court of Appeals had jurisdiction to consider the government's appeal, and we have jurisdiction to review and summarily vacate the court's erroneous judgment. Guys who are just joining and fighting in the comments, we are reading the court's emergency order that just came down that effectively rejects the Trump administration's efforts to cancel $2 billion in foreign aid. It will effectively put in place a lower court order that requires the Trump administration to pay out this $2 billion through USAID. It was a 5-4 decision with the Chief and Justice Amy Coney Barrett joining the court's more liberal justices in the majority. I'm reading from the dissent right now, which was Alito, Thomas, Kavanaugh, and Gorsuch. Even if the majority is unwilling to vacate the district court's order, it should at least stay the district court's enforcement order until the government is able to petition for a writ of certiorari. In considering that's you asking the Supreme Court to hear your case on the merits. In considering whether to issue such a stay, we ask at a minimum whether the moving party is likely to prevail on the merits and whether the moving party is likely to suffer irreparable harm. In close cases, we also take into account other equitable considerations. Here, these factors weigh in favor of a stay. Likelihood of success. The government has shown a likelihood of success on the merits of its arguments that sovereign immunity deprived the district court of jurisdiction to enter its enforcement order. Sovereign immunity bars a suit by private parties seeking to impose a liability which must be paid from public funds in the Treasury. That's quoting a case from 1974. But that is exactly what the district court ordered here. In a claim that the government is liable for awards of monetary damages, the waiver of sovereign immunity must extend unambiguously to such monetary claims. Attempting to satisfy this strict requirement, respondents point to the APA's waiver of sovereign immunity for certain actions seeking relief other than money damages. That language, as we have explained, distinguishes between specific relief, which is permitted under the APA, and compensatory or substitute relief, which is not. But the relief here more closely resembles a compensatory money judgment rather than an order for specific relief that might have been available in equity. Sovereign immunity thus appears to bar the sort of compensatory relief that the district court ordered here. Hoping to escape that conclusion, respondents point to Bowen v. Massachusetts' case from 1988. In that case, again, we're reading from the dissent of the Supreme Court's emergency order just a few minutes ago, requiring the Trump administration to pay out this $2 billion in foreign aid. This is the dissent. I'm reading as much of it as I can before we get merits opinions at 10 a.m. in 9 minutes. There are only 3. In that case, we held that this is the Bowen v. Massachusetts case. In that case, we held that the APA's waiver of sovereign immunity covered a district court's judgment reversing a final order of the Secretary of Health and Human Services, refusing to reimburse Massachusetts for certain Medicaid expenditures. Unlike the district court's order here, that judgment did not purport to order that any payment be made by the United States. Rather, Bowen simply recognized a basic reality of APA review. After a court sets aside an agency action, a natural consequence may be the release of funds to the plaintiff down the road. Indeed, we have since clarified that Bowen has no bearing on the unavailability of an injunction to enforce a contractual obligation to pay money past due, the sort of relief that appears to have been ordered here. The dissent here is quibbling with the fact that the district judge entered a TRO, but they're arguing it's not really a TRO in practice because it is requiring the government to take affirmative action to pay out $2 billion in aid that has already been allocated, rather than temporarily pausing the status quo because the money would effectively be lost forever, and that is likely irreversible. This is their argument. The district court, however, failed to maintain, much less reckon with Bowen or Knudsen before plowing ahead with its $2 billion order. Nor did it take account of our previous suggestion that the proper remedy for an agency's recalcitrant failure to pay out may be to seek specific sums already calculated and past due in the Court of Federal Claims. The most that can be said is that in the district court's denial of the government's motion for a stay pending appeal, it cited but did not analyze a handful of cases echoing Bowen's discussion of the APA's conscribed waiver of sovereign immunity. One might expect more care from a federal court before it so blithely discards sovereign dignity. They're really slapping down the federal judge here who made the order. Finally, we're getting to the end here. Finally, the government has a strong argument that the district court's order violates the principle that a federal court may not issue an equitable remedy that is more burdensome to the defendant than necessary to redress the plaintiff's injuries. In this case, the district court's enforcement order functions as a universal injunction, defying these foundational limits of equitable jurisdiction. The district court ordered the government to pay all invoices and letter of credit drawdown requests on all contracts for pre-TRO work completed. That order encompasses more than just respondents, and the district court offered no reason why universal relief to non-parties is appropriate here. And this is not the sort of case in which the only universal relief is feasible. Even supposing the APA allows universal relief, universal vacatur or vacator of rules in some circumstances, the district court's order of direct monetary payment bears no resemblance to that. And nobody has suggested that the government is unable to identify respondents' allegedly owed funds and pay out only to them. Limiting the scope of relief in that manner would be significant. Below, the government represented respondents seek roughly $250 million, still a large figure, but a fraction of the $2 billion ordered. That's a citation. Harm to the parties and others. This is another factor. The government has shown that it is likely to suffer irreparable harm in the district court's order if the district court's order is not stayed. The government has represented that it would probably be unable to recover much of the money after it's paid because it would be quickly spent by the recipients or dispersed to third parties. Respondents did not credibly dispute this representation, and the district court did not find that it is incorrect. We usually balance the equities and weigh the relative harm in close cases. For the reasons I have explained, this is not such a case, and our analysis could end there. Nevertheless, respondents' equitable arguments are insufficient to justify the denial of a stay. They contend that the failure to pay the money in question would cause them irreparable harm because without those funds, they could not continue to operate or would have to reduce the work that they do. As a result, they claim recipients of their services would suffer. These potential consequences are, of course, serious, but any harm resulting from the failure to pay amounts that the law requires would have been diminished, if not eliminated, if the Court of Appeals had promptly decided the merits of the government's appeal, which it should not have dismissed. If we sent this case back to the Court of Appeals, it could still render a prompt decision. If it decided in favor of the respondents, the government would be obligated to pay all the money that is due, and respondents would have suffered only a short delay in the receipt of payments. And if the government prevailed on its sovereign immunity argument, neither respondents nor any of the recipients of their services would have suffered any unlawful consequences. In sum, the factors we consider in deciding whether to issue a stay weigh strongly in favor of granting that relief. Today, the court makes a most unfortunate misstep that rewards an act of judicial hubris and imposes a $2 billion penalty on American taxpayers, really going after the judge here. The district court has made plain its frustration with the government, and respondents raised serious concerns about non-payment for completed work, but the relief ordered is quite simply too extreme a response. A federal court has many tools to address a party's supposed nonfeasance. Self-aggrandizement of its jurisdiction is not one of them. I would chart a different path that the court does today, so I must respectfully dissent. Somebody just clock all of the shade that they throw on the district court judge. You can just write them all in a list, but there's a lot. Okay, so we have 3 minutes until the court will release one or more decisions from an argued case this term. That was just the court's emergency order that effectively puts in place, it denies the Trump administration's efforts to cancel this $2 billion in aid, and it reinstates a district court's order that effectively requires the Trump administration to pay out this $2 billion in foreign aid. That was an emergency order. We just read through it. It was a 5-4 decision. The chief, Amy Coney Barrett, Sotomayor, Kagan, and Jackson were in the majority. Alito, Thomas, Gorsuch, and Kavanaugh were in dissent. I just read their somewhat lengthy dissent. There was some question about why this was taking a bit of time, and it's clear that it's because someone was writing a dissent, and it was Alito writing this dissent going after the federal judge who he thinks doesn't have jurisdiction. This is the decision about foreign aid for somebody who's just asking. So what happens if they don't follow the order? That is a great question, and I don't know exactly. The court has several methods to attempt to enforce its own order, but we'll see what happens. Now the Trump administration has been ordered, and that order is back in effect to pay out the $2 billion. All right, so 1 minute till we get opinions. While I'm thinking about it, we are working at SCOTUSblog on a piece about using the seat reservation system at the Supreme Court. So if any of you guys have done that, can you email the feedback at SCOTUSblog email address and tell us how it's been? Because we're going to write up what that process has been like, since it's the first time the court has ever opened up the room for reservations. The USAID decision, Shannon, was that the Trump administration is going to have to pay out the $2 billion. The Supreme Court vacated their administrative stay, or removed their administrative stay, which reinstates the lower court's order, the district court's order, requiring the Trump administration to pay out the money. So it's a loss for the Trump administration. It was a 5-4 decision. Thank you, Bernadine. All right, it's 10 a.m. So we're going to get one or more decisions from the Supreme Court's merits docket, even though it's already been a busy morning. I'm going to hit refresh on the Supreme Court's website till we get the decision. Let me know, of course, if you get it before I do. They did not hear full arguments already in the USAID case, completely lawless. This was an emergency/shadow docket decision where the parties rushed up. You may remember the chief, just before the midnight deadline on paying out the funds that was set by the lower court, the chief issued an administrative stay, and they bought themselves a little bit of time. And today they were just making a decision on whether or not, they basically said the deadline had passed in the lower court's order. And they have ongoing preliminary injunction proceedings. So the administrative stay is lifted, and the lower court's order, the TRO, is back in effect that requires the Trump administration to pay out that money. This was not a fully briefed, fully argued case. This came up to the court in an emergency posture. I'm hitting refresh on the Supreme Court's website as we're getting at least one decision from a merits case this term. Sometimes it takes a minute or two. Has anybody gotten the decision yet? Let's see. You can also follow along on SCOTUSblog's live blog. I didn't get a document count, a box count this morning because I was refresh, refresh, refresh. The first and only opinion of the day, Amy has it. It's Bufkin v. McDonough by Justice Thomas. The vote is 7-2. Jackson dissents, joined by Gorsuch. Actually now, Bufkin v. Collins. Secretary of Veterans Affairs. Okay. Justice Thomas delivers the decision of the court. Joined by Roberts, Alito, Sotomayor, Kagan, Kavanaugh, Barrett. Jackson dissents, joined by Gorsuch. The VA's determination that the evidence regarding a service-related disability claim is in approximate balance is a predominantly factual determination reviewed only for clear error. All right, so this case, I'm going to read a bit from the top of Thomas's decision, but this is about the VA making a determination for service-related disability benefits. The Department of Veterans Affairs applies a unique standard of proof known as the benefit of the doubt rule. This rule requires the VA to give the benefit of the doubt to the claimant whenever there is an approximate balance of positive and negative evidence on any issue material to the claim. When reviewing the VA's benefits decision, this is the only decision of the day, in addition to the emergency decision we just got on USAID. When reviewing the VA's benefits decision, the United States Court of Appeals for Veterans Claims must take due account of the VA's application of the benefit of the doubt rule. The question before us is whether the Veterans Court what the Veterans Court must do to comply with the statutory command. We hold that the Veterans Court must review the VA's application of the rule the same way it would any other determination, by reviewing legal issues de novo and factual issues for clear error. And we hold the VA's determination that the evidence is in approximate balance is a predominantly factual determination reviewed only for clear error, which is a stronger level of deference given to the VA's determination based on the benefit of the doubt rule. Let's see. Congress provides veterans a wide range of benefits, including compensation for disabilities caused or aggravated by active duty military service. The VA, led by the Secretary of Veterans Affairs, administers the laws that provide for those benefits. Veterans who suffer from service-connected post-traumatic stress disorder are among those entitled to disability benefits. To establish service-connected PTSD, the VA requires medical evidence diagnosing the condition and linking the veteran's symptoms with an in-service stressor, as well as credible evidence with an in-service stressor occurred. When the VA finds those conditions satisfied, it assigns a disability rating that reflects reductions in earning capacity. This rating determines the amount of compensation a veteran receives. A veteran begins the claims process by submitting a request for benefits to the VA. I'm going to skip briefly to the somewhat strange bedfellows in dissent, Jackson and Gorsuch. Justice Jackson dissenting, joined by Gorsuch. The dissent is just as long as the opinion, it seems. Actually longer. The court draws two conclusions from today's evaluation of Congress's take due account admonition. First, it holds that when the United States Court of Appeals for Veterans Claims reviews the Department of Veterans Affairs application of the benefit of the doubt rule, that appellate tribunal must use the same standards of review that apply to its assessment of any other VA claims determination. Second, the court concludes that whether evidence is in approximate balance for purposes of the benefit of the doubt rule is a predominantly factual determination to be reviewed only for clear error. The majority is wrong in both respects. Nothing about the text, context, or drafting history of the law demonstrates that take due account actually means proceed as normal. Reading the provision in that fashion, as the majority does, makes little sense. That interpretation is also inconsistent with how we have treated identical language elsewhere in this same statute and renders meaningless the take due account command that Congress specifically amended in this section of the law to insert. The majority's clear error conclusion fares no better, insofar as its reasoning ignores what appellate courts do and what we have consistently said about substantially similar circumstances. That is, even if the majority were correct that subsection B1 instructs the Veterans Courts to carry on applying the usual standards, clear error review would not be appropriate because whether the VA properly applied the benefit of the doubt rule does not present a question of fact. The VA's benefit of the doubt determination poses at most a mixed question of law and fact, and one that is substantively indistinguishable from the kinds of mixed questions that this court has long said are subject to de novo review on appeal. This is about the standard of review that applies when there's a legal issue and an appellate court is reviewing that. They do it de novo because they're taking a fresh look at the legal analysis and the legal conclusions, but the district court or the lower court or the agency are typically viewed as the fact-finding bodies, and they are the ones who kind of mine all of the facts and put that together. So when an appeals court is reviewing a factual decision or an assessment based on the facts, that is the job of the fact-finding body, the lower court, then that is typically reviewed for clear error because there's a great deal of deference given to the fact-finding job of the lower court, or in this case, I guess, the agency. In short, the court today concludes that Congress meant nothing when it inserted the law in response to concerns that the Veterans Court was improperly rubber stamping the VA's benefit of the doubt determinations, and also that the Veterans Court is not obliged to do anything more than defer to those agency decisions, notwithstanding Congress's take to account direction. I respectfully dissent. This benefit of the doubt rule is that veterans asserting claims for service-connected disabilities are entitled to have any reasonable doubt on a material issue resolved in their favor, which makes sense. All right, so one decision today. On the merits, one decision from the emergency docket. Here's the recap. In an emergency order shortly before we got this decision, the Supreme Court reinstated a lower court judge's decision or lifted their own administrative stay that will require the Trump administration to pay out $2 billion in foreign aid and assistance. This is a loss for the Trump administration, who is effectively trying to cancel at least $2 billion, if not more, of this aid. And now the question is, how the Trump administration will respond. But this is really the final order on this piece, this $2 billion piece that was ordered by the district court judge, basically on payments for work that had already been done. It was a 5-4 decision. Justice Amy Coney Barrett and the Chief joined the court's more liberal justices in the majority, and Alito, Thomas, Kavanaugh, and Gorsuch dissented. It was sharply critical of the district court judge in this case numerous times throughout that decision, and the dissent clearly believes that the United States government has sovereign immunity from these types of claims that were brought up. And then we got the merits decision today in Bufkin v. Collins. It was Bufkin v. McDonough, but now Doug Collins heads up the agency, that clarifies the standard that has to apply when the Court of Veterans Claims and Appeals is reviewing determinations on benefits that are given to veterans who have a service-related disability. And the analysis applies something called the benefit of the doubt rule, which is the standard of proof that's written into the statute that requires the VA to give these claimants the benefit of the doubt when there are questions about the disability and its connection to service. That's the two decisions. Those are the two decisions. Today, the veterans' decision was 7-2. Justice Thomas writing the majority, and Justice Jackson joined by Justice Gorsuch in dissent. Also, I'm going to remind you, for anyone who's on, if you have done the seat reservation at the Supreme Court, please email us at feedback@SCOTUSblog.com, because we're writing a piece on how that's working and how that's going. Tell us what your experience has been. Yes, because yes, it is a win for veterans. But well, depends on how you look at it. But it places a higher burden to overturn a decision that was made on benefits claims. So I don't know. It could actually go either way. Depends on if they gave you the benefits or didn't give you the benefits. Okay. No, that was the final decision for today. I don't think it doesn't mean anything for veterans who already have a service-connected disability. This is about people who are going through the claims process going forward, and using the benefit of the doubt rule when determining whether and to what extent a claimant has a disability that's connected to service, and then what the appeals court, the Court of Appeals for Veteran Claims, the standard of review they use when they're analyzing the VA's decision. I believe the $2 billion was for work already done. That's how the dissent also categorizes it. You're welcome, Max. Thank you. Thanks, Marcella. Will there be more decisions this week? None on the merits that we're aware of. I mean, the court could always decide to, but typically they tell us, like last week we knew Tuesday and Wednesday would be opinion days. So it's unlikely that we will have another opinion day this week. Typically, they tell us the week before. Can you help with understanding more on the VA? Okay, so when a veteran is claiming that they have a service-related disability and they want service-related disability benefits, they go to the VA. And the VA, the Department of Veterans Affairs, applies this standard called the benefit of the doubt rule that basically gives the benefit of the doubt to the veteran who's making this claim when there are close questions, essentially. The question in this case was when there is an appeal of a decision that's made about the benefits, the disability benefits, what standard the Court of Appeals for Veterans Claims uses when they're analyzing that specific piece. And what the court said is that counts as a factual analysis, which is reviewed for clear error. The VA's determination that the evidence is in approximate balance is predominantly factual determination reviewed only for clear error. So basically, the Court of Appeals for Veterans Claims can't overturn the VA's determination using the benefit of the doubt rule unless it is clearly erroneous, clearly wrong. It's a higher standard for review. Does that help explain it a little bit better? Yeah, a lot of people asking what happens if the Trump administration doesn't comply with the court order. We'll see. Courts have certain powers to try and compel compliance with their orders. We'll see if they have to use any of them. But, I mean, ultimately, as a number of Supreme Court justices have said, the courts do not have an army to enforce their orders. They rely on the public's trust and faith and compliance with their determinations and the rule of law. That's part of what makes our system work. Oh, I'm so sorry to hear that, Stacy. I can imagine. You're welcome, Kathy. Yes, likely igloo freeze. I haven't seen if the Trump administration has issued any kind of response to the emergency decision. You guys let me know if you see any. Do bench slaps have political tones, or are all decisions merits based? I mean, the justices would say no, but it depends on your definition of politics. I mean, here it was the 4 of the court's conservative justices. I mean, 2 of the court's conservatives were in the majority on the other side. But I think you can read the court's dissent as a number of bench slaps for the district court judge. Quick recap Darcy is asking for. Yes, we got 1 emergency decision from the Supreme Court and 1 merits decision from the Supreme Court. Recap. Sorry, I got an email at the same time. Recap. In the emergency decision, the Supreme Court basically rejected the Trump administration's efforts to not pay out this money via USAID. They will now be required to comply with a lower court order. I'm trying to decline. With a lower court order compelling them to pay $2 billion via USAID for, I believe, work that's already been done. That's what the judge's order said. The second decision was about veterans who are applying for service-related disability benefits, and the way that the VA's ultimate decision on the request for disability benefits gets reviewed if it gets appealed up to the Court of Appeals for Veterans Claims. And the Supreme Court basically said, the Court of Appeals for Veterans Claims can only reverse the VA's determination on disability benefits if they find, using this something called the benefit of the doubt rule, if it's clearly wrong, which is a pretty high standard. It has to be clear error for the Court of Appeals of Veterans Claims to reverse that determination made by the VA on the amount or whether to provide disability benefits for service-related injury. Those are the 2 decisions. Yeah, actually, JMD, if you just go to my, I posted a TikTok last night recapping yesterday's decision. It's quick. But basically, San Francisco won in their challenge of EPA's regulations on water quality standards, which is not necessarily something you would expect. But there's a quick TikTok on it already. I just posted it last night. You're welcome. You're welcome, Hospice Sally. Anybody seeing any response yet from the Trump administration to the order this morning? Be curious to see how that goes throughout the course of the day. I don't see anything yet. Jay Valdez. Sounds like you are a bit of an EPA standards nerd. Maybe this is more in your area. So San Francisco, the EPA, in issuing permits that allow for offshore discharge or pollution, required limits on the amounts or type or concentration that could be polluted, but they also, in 2019, started applying a water quality standard. And if the water overall dipped below a certain quality level, then the permittee could be found responsible in violation of their permit and held criminally liable or face hefty civil fines. And San Francisco, who had these permits, and this was largely dealing with human waste discharge, challenged the EPA's ability to impose these water quality standards, saying they were ambiguous, they were impossible to comply with, even if they followed everything else they were supposed to do. The water quality could dip below a certain amount. And so they found themselves on the side of industry, who defend this type of discharge, environmental discharge. And they won. The Supreme Court's conservative majority agreed with them. And it was a 5-4 decision. Justice Amy Coney Barrett joined the court's liberal justices in dissent, saying the EPA did have authority to impose those types of water quality standards. And just the limits on amount or type or concentration that could be discharged were not enough, because there were examples in this case of floating debris in San Francisco off the coast, including toilet paper and other things. It's kind of gross. That was yesterday's decision. There really isn't anything left to appeal from today's emergency order. They have to go back down to the district court, whose order is in effect right now. And the DC Circuit has already said that it's not appealable to them. So this was the last resort for the Trump administration in this. All right. Any other questions? Thanks, Hospice Sally. Yes, you all get one final recap. We got an emergency decision from the Supreme Court before we got the merits decision that rejected the Trump administration's request to cancel this $2 billion in foreign aid that they were ordered to pay out by a district court judge. Now that district court judge's order is back in effect, so the Trump administration is required to pay out this at least $2 billion in foreign aid. In a merits decision, the Supreme Court clarified the standard that applies for the Court of Appeals for Veterans Claims when they are reviewing the VA's determination for a disability benefits claim. And they basically said that when the VA is making this determination, they're statutorily required to apply what's called the benefit of the doubt rule, giving the veteran claimant a benefit of the doubt in closed questions, and the Court of Veterans Claims has to review that for clear error, meaning they can only reverse the VA's determination on disability benefits if they find that they are clearly wrong about something in the way that they considered it, in the facts that they considered. And those are the two decisions we got. Somebody should start counting the number of recaps we do each time there's an opinion day, but I'm happy to do them. To an extent. Eventually, I'll just do the TikTok, and you can find it later this evening and see the summary. Nope, that's the final decision today and should be the final opinion day of the week. The ruling does not affect future aid. This was really just about the emergency TRO that was in place that required the Trump administration to pay out the $2 billion on contracts for work that had already been completed. You're welcome, Max. Thank you, Ivy Neck. Do I have any insight into how decisions are written? Do clerks write it or do justices? My sense is, for the most part, clerks write the first draft and second and third and fourth draft, but with, after that initial drafting phase with input from the justices. And sometimes, the justices can do a heavier rewrite, but it's a joint effort. Thank you, Tint Mom 6. All right, guys, I'm going to go do my other job for the day. But as always, it was fun to join you for an opinion day. Today we got a double whammy with the emergency order right before opinions came down. Query whether that emergency decision was ready to go last night, but they just didn't put it out because they didn't want to deal with Trump talking about it during his State of the Union speech. Who knows if there was strategy there or not. All right, happy Wednesday? Today's Wednesday. Hi, Jason. Happy Wednesday to all. I hope you have a good rest of the week. We'll be back here if we have another Opinion Day live. Otherwise, I'll just do a TikTok recap. And I'll see you next time we have a decision. You can go listen to oral arguments right now if you want, live at the Supreme Court's website. They're hearing another case today too. All right, guys, have a good week.